All right, Bree, what's on your radar?
Well, Kim, yesterday evening, the CDC issued a statement indicating that it would appeal the Florida District Court decision to end mask mandates in public transportation settings. Now, obviously, given how politicized the conversation around masking has been since the start of the pandemic, the reaction to this news has largely been driven by ideology. Those who have supported mask mandates, largely liberals, are rejoicing. Those who have opposed masks, largely conservatives and independents, are livid. Even some who are supportive of mask mandates are warning that this could be a political blunder by the Biden administration because the ruling, they argue, gave Biden an out. The population is divided on mask mandates, so it could be a lose-lose for the party in power to act in either direction. Since the mandate was ended by the courts and not Biden, the administration arguably could have sidestepped responsibility for ending the mandates if it let the courts do its dirty work. But I'll leave that debate to others. What I'm interested in is explaining today why, from a legal perspective, it makes sense for the administration to appeal the decision. However you feel about mask mandates, the decision simply made terrible law. What do I mean by that? Well, legal decisions are not just a one-off. They have what is called precedential effect. Decisions are binding or controlling on lower courts and have a persuasive effect on courts at the same level. That means that any bad reasoning that wrongly interprets the law could have the effect of changing the law for future litigants in a way that betrays the intent of the democratically elected legislatures who wrote said laws. Conservatives who are skittish about, activist judges for this reason should take note. Judge Catherine Mizell's opinion, striking down the mandates, has much broader implications than just COVID and masks. And even if you are antagonistic to mask mandates, you should be concerned that she decided the case on the basis that she did. I'm going to explain all this in more detail, but first let me make something clear about my own perspective on mask mandates. I am moved by arguments that mandates are not sufficiently narrowly tailored to achieve the desired effect of constraining the spread of COVID, because they make no distinction between high-quality masks and low-quality masks, which have limited efficacy. I'm also skeptical of the inconsistencies of some of the guidance that have been promulgated for different types of spaces, restaurants versus stores, for instance. And I'm infuriated by the hypocrisy of legislatures who at times engage in mask moralism for working people while engaging in high-risk behavior themselves. It's exactly that kind of behavior that has undermined the credibility of the CDC in the first place. However, none of this changes the fact that Mizell's legal decision is terrible. It's just terrible reasoning, it's terrible logic, and most importantly, it's terrible law. Now, as you might have heard, her opinion turns largely on the reading of the word sanitation. Here's why. This is a little wonky, but stick with me. Administrative agencies like the CDC are granted authority by Congress via statute, i.e. laws. In this case, the plaintiffs challenged whether the statutory authority of the CDC extended to mandating that people wear masks on public transport. In other words, does the CDC's authority extend that far? To answer that question, it's important to understand what the statute granting the authority actually says. Okay, so the CDC claimed authority based on the Public Health Services Act. The act says that, quote, the CDC, with the approval of the Secretary of Health and Human Services, is authorized to make and enforce such regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries into states or possessions, or from one state or possession to any other state or possession. For purposes of carrying out and enforcing such regulations, the CDC may provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary. If you're thinking, that sounds pretty clear-cut, I'd agree with you. It says that the CDC is authorized to make regulations necessary to prevent the spread of communicable diseases between states, requiring masks does that. So where's the rub? The answer is there is none. The statute says the CDC can regulate where, quote, in his judgment, it may be necessary to, quote, prevent the introduction, transmission, or spread of communicable diseases between states. Now enter Judge Mizell. The problem with her isn't that she's young. People have made a lot of the fact that she's 35. It's not that she's a Trump appointee, and it's not that she's stupid. People who know her say that she is a very promising young jurist. She just happens in this case to be wrong. Despite the clarity of the statutory authority, Mizell uses principles of statutory construction to make a very convoluted case against taking the obvious meaning of this paragraph. Now, principles of statutory construction exist because sometimes statutes are unclear. Language is messy, and there are a lot of bad writers out there. Many of them are in the legislature. These rules are intended to provide some clarity and consistency for courts looking to divine what the people who drafted the laws really meant when they are ambiguous. However, there's no ambiguity here, and even if there were, Mizell completely bungles the applications of those principles of statutory interpretation. Judge Mizell notes that according to Supreme Court precedent, when there is a list of enumerated actions, in this case, the part of the statute that says the CDC can provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles, that part, the action that is taken by the agency has to fall within one of those listed items, even if in this case there's a broader statement that the administrative agency may use its judgment as necessary. Okay, so fair enough. The word sanitation seems to cover what's at issue here. Wearing a mask seems to obviously be a sanitation measure. How do we know? Well, another principle of statutory interpretation says, hey, when we don't know a plain meaning of the word, open a dictionary to get a common sense of what it is. Who would have thunk it? What will lawyers dream of next? So what does the dictionary say about the word sanitation? Well, Mizell admits in her opinion that one of the common dictionary definitions of the word sanitation refers to public health. She tucks it in a footnote rather than leaving it in the body of the opinion, but it's right there on page 13. Some dictionaries define sanitation as relating to the public health. However, for some reason, she defaults to two other definitions of the word, arguing, using still other rules of statutory interpretation that are truly not necessary to understand what is a pretty straightforward text. She decides that sanitation refers to, quote, measures that clean something, not ones that keep something clean. Measures that clean something, not ones that keep something clean. Okay, so bear with me. I'm not trying to make anyone uncomfortable here with this example, but I can think of one pretty obvious and common use of the word sanitary, one that comes up for about half the population every 28 days with the cycles of the moon. Yes, I'm talking about sanitary napkins. Last I checked, a sanitary napkin isn't used to clean a woman's downstairs, it's used to keep her underwear and clothes clean when she's menstruating. Just like a mask is used to prevent the spread of a virus, even if it's not intended to literally identify, isolate, or destroy the disease itself, as Mizell claims the statute requires it to. Even the statute's own text undermines Mizell's reading of it. It mentions pest control. Pest control, explicitly stated as within the authority of the CDC to regulate, doesn't identify, isolate, or destroy disease. It simply attacks the vector, limiting the spread of disease by limiting the pests that carry it. The rats or mosquitoes, for instance, aren't the disease. Black Death or malaria are. Ian Millhiser, writing in Vox, puts it this way. Quote, suppose, for example, that many toilets installed in airplanes had a design defect that causes them to spew sewage into the cabin. Under the ordinary definition of the word sanitation, the CDC could order airlines to fix these toilets to prevent passengers from being exposed to sewage in the first place. But under Mizell's definition, the CDC would have to wait until passengers were wading through feces before it could order the airline to clean it up. That's the natural consequence of saying the law applies only to measures that clean something, not ones that keep something clean. It goes downhill from here, and I'm already running long, so I'll refer you to Millhiser's piece, or if you're a real pain pig like me, you can read the 59-page opinion. I paid for law school, I might as well use that degree. But I promise you, if you do, you'll find no sound legal justification for getting rid of the mask mandates. Now, this is not to say that the mask mandates in their current form are politically or even scientifically indicated. As I said, the mandates foolishly don't distinguish between masks of different quality, and they aren't well tailored to minimize the risk of spreading COVID. Many of the rules were clearly based on business decisions, like a desire to protect the restaurant industry and allow them to reopen. Fair enough, people can fight about the legitimacy of those kinds of choices, but they have nothing to do with the science of masking, just as this legal opinion has very little to do with the law. Now, I can appreciate why the Biden administration doesn't want this bad law in the books. It represents a politically motivated narrowing of the CDC's authority to act in response to public health emergencies like the one we're in. We might face another one any day, and the one we're in could escalate or change in ways that require the CDC to respond. And if its hands are tied, we could experience even more preventable deaths than have already occurred. Whether appealing this decision is worth the political cost of angering a significant portion of the country, who knows? I'm no politico. To be clear, I'm just a lawyer standing in front of a court opinion, asking it to make sense. Make it make sense for me, Kim. Like this to me, it's not, I completely understand the arguments for and against masking, but I read this out of curiosity to see what the grounds actually were. And I don't see a lot of justification in saying that the argument that the CDC does not have the authority to do this holds.
Well, I actually think that's the most compelling aspect of the ruling. She actually gave 3 different reasons for the judgment, right? So she said focusing on sanitation was one. And I think the reason why the judge focused on sanitation in particular was because that's what the parties litigated on. So I think that is what the CDC was arguing, as well as so I think that is why the focus was on sanitation versus, like, for example, in that paragraph, it does say and other measures, but I think they had a cabinet into something. And so they just said, okay, it's way too broad to say
so one of the rules of statutory interpretation is that if there's a list like that, you have the thing you're trying to do has to fit into one of the words in the list. So I think that's completely fair, and that's why sanitation was at play. Sure, I'm sorry.
Right. So I do believe that they focused on sanitation for that particular reason. But so I gotta push back on the definition of sanitation. I don't think anyone believes that sanitation means public health. So I think that in the dictionary, when it says sanitation is relating to public health, I think that means it's a cleaning relating to public health versus, for example, cleaning your computer's hard drive. That is not related to public health. So therefore, you're not sanitizing by definition of what sanitation is based on the actual dictionary's, the definition. So sanitation has to be cleansing that is specifically in context of public health, not some other type of cleaning like a computer hard drive. So I think that is where maybe the public health aspect to sanitation comes in, but I still think sanitation means cleaning, even if, yes, I understand.
Sorry, can you cut out for me a little bit there for a second? Well, I lost your audio, but keep it in mind, this definition is within the Public Health Sanitation Act. The clear context of this statute is the Public Health Act. So when we're talking about sanitation, there are obviously different meanings of the word, some of which are completely outside the context we're talking about. So I'd agree, obviously, it doesn't extend to something like a computer hard drive. And the case law gets into that, and they work through that in the context of this brief. But when you open the dictionary definition of the word sanitation, she's not arguing that it doesn't mean to clean. Judge Mizell isn't arguing that the term sanitation doesn't apply to things that the CDC can do. To the contrary, she's saying the CDC should apply to sanitation. What she's doing is narrowing the definition of the word sanitation such that it only covers cleaning things up after they get dirty, as opposed to doing things to prevent something to become unsanitary, which I think bulks everybody's understanding of what various sanitary products, which to my point, like a sanitary napkin, are meant to do. Or lying down, let's say, a sanitary tarp before conducting a surgery, or any other kind of provision that you would take to prevent disease from spreading before the fact.
Well, the CDC has not only jurisdiction over sanitation measures, I suppose, but also, for example, to prevent contamination. So I think in certain circumstances, they're able to make recommendations or even rule, or put out, I don't know what you want to call it, when they mandates, I suppose. They can mandate certain things happen based on other things other than sanitation. So fumigation, preventing contamination. Right. So there's a broad scope of what the CDC can make mandates, regarding not just sanitation, but in particular, I think that the parties litigated on sanitation. So she had to specifically focus on what the parties litigated, not the scope of what the CDC can or cannot do. So specifically for sanitation, I think sanitation means cleaning. And I think most of us believe that. Now, what a sanitary pad is called, napkin, that's just marketing. I mean, I don't think that the CDC is necessarily claiming, I don't know if they're the ones that gave the sanitary napkin its name. That's, I guess, any marketing company or any company could call whatever they want sanitary anything, but it doesn't. So I don't know if I would use that particular argument, but I would certainly say that the CDC has a broad range that they could regulate, a broad scope, not just sanitation. But that is what the parties litigated. So that is what she was stuck with. But the ruling had way more to do than just sanitation. She also talked about the what was it? The notice and comment section. The public didn't get a chance to actually comment on this. How long can an emergency last without turning to the public? But then lastly, I think that her argument or her judgment or ruling really focused a lot on the merits of the case. This was a substantive ruling in that she was really looking at the merits of the CDC's mandate and saying they just didn't prove their case. They didn't actually put forward enough evidence, and particularly they didn't put forward enough evidence to explain the exceptions, like why a 2-year-old doesn't have to wear, like how is a 2-year-old less likely to spread the virus or catch the virus compared to somebody else, or why can you take it off when you're eating and drinking? The inconsistencies were the biggest, I think, issue.
And as I mentioned, I think a lot of those inconsistencies are fair, but the question of whether or not the Biden administration should be pursuing an appeal is, I think, related to the fact that bad law is made in constraining the CDC's authority. Yes, it has to turn on sanitation. Yes, the litigants, the plaintiff, was arguing sanitation because they have to, but the law says you define sanitation by the common dictionary definition. That's what the rules of statutory interpretation says. And she goes out of her way to ignore what's right there in the dictionary, right here on page 13, that says sanitation is about not just cleaning, but keeping things clean as well. And that's something that I think that people should know. And that's why we went through this today. I appreciate you working through the wonkiness with me today, Kim.
There's other agencies, though. There's other agencies that can regulate this type. I think like the sanitation with the toilets, I don't think the CDC does that. I think that's actually a different department, or agency. But so maybe there's other ways, if Biden really wants to go for it. But I agree with you from the beginning of your radar that this would be politically, I don't know what they're thinking, if this is a good idea or not to pursue, because politically it could be, just, I guess Biden really loves low polling numbers. I don't know,
We'll see what happens. Thank you, Kim.
All right. Yeah. Well, I don't have a radar today. Yes, I don't have a radar today, but because I had to wake up too early, so I couldn't stay up all night writing and researching, doing all the wonderful work that Bree just did. So we have more Rising instead coming up next.